Welcome back to the Personal Injury Show. Before the break, we were discussing a very sad case running in Sydney. Girl who ate a chicken twister from Kentucky Fried. She was 7 at the time. She's now 11, and she's suing Kentucky Fried Chicken for salmonella poisoning, which she says arose from eating the chicken twister. The press has the headlines as suing for $10 million, which we'll come back to, but how difficult is the case?
Well, the difficulty is trying to link the salmonella poisoning to the actual twister, that chicken wrap, whatever you call it, and in circumstances where the Health Commission's been there and they've inspected the premises and they said that they're in pretty good condition. So you need complaints, Harry, and there was a lot of complaints by other family members. They got sick after eating this wrap, and also the thing is, one of the other family members ate a schnitzel, I think it was, and she didn't get sick. So all family members, including this tragic 7-year-old, ate that chicken wrap, and so
and they got sick.
They got sick.
Then,
but in her case, the doctors are saying that the salmonella went outside the stomach into the bloodstream, and that's why she's developed this quadriplegia and significant symptoms.
Well, there's brain damage and quadriplegia, so it's a terrible, terrible consequence. The KFC, their insurer and their lawyers are defending the case on liability. They feel sorry for the girl.
They're fighting it on causation, Harry,
and they're saying that how do you prove that the salmonella arose from the chicken twister, and how do you prove it? I mean,
well, what I think they've done in this is that the family members, all the ones that got sick after eating the same chicken wrap, that evidence is going to be pretty supportive, pretty helpful.
Strong.
It was contemporaneous. I mean, they all got sick pretty soon after eating
within a very short period of time.
They went off to doctors and hospitals and things like that. Plus, the auntie that ate the schnitzel didn't get sick, so that's an indicator of the twister. And they're going to have to look at what else they ate in that period of time, things like that, what they drank, what they ate, those sorts of things. Plus, what's of significance is, I think they've actually gone and spoken to employees of the store, and there's a lot of talk about, we don't know what the evidence is yet because, I mean, the case has just kick-started, but I think they've got witnesses to say that they weren't really hygienically minded.
In the KFC at that period of time.
Yeah.
So,
but I mean,
look, KFC are generally reasonably run. You know, they pride themselves on having...
It's a massive chain, Harry. So.
Yeah, they pride themselves on having very efficient, clean restaurants and you know, food outlets. So, you know, at least they try. And whether they've reached that standard and whether you can prove...
Well, it's only a reasonable duty of care.
Yeah.
Although they've sued on more than one basis, haven't they?
Yeah, they've sued under the Trade Practices Act for a faulty product. So, and plus in negligence, saying the standard of care wasn't suitable. So there's no argument, they've got a duty.
I'm not really sure what I even bothered to sue under the Trade Practices Act, because the only issue really
you'll have to contact their lawyers.
The only issue really is causation. You know, the link between the damage and the eating of the
twister.
Wrap.
Yeah.
So, and you'd think that your damages are probably under Victorian law. Your damages are higher if you can sue under the Wrongs Act as opposed to the Trade Practices Act.
Lawyers have got to make choices about how to present the case and what...
They're suing for 10 million. Harry, how'd they get to the 10 million?
Most of it would be future medical care. So
24-hour care, right around the clock.
Yeah, she's in a wheelchair, and I think that the sensible thing for the lawyers for the defendant would be to mostly agree on what the claim is worth. They can argue about whose fault it is and whether you can prove KFC are at fault, but generally you'd think you'd reach some agreement.
Yeah, you'd have occupational therapists that would have prepared detailed reports about the cost of looking after this girl between the age of 10 up until whatever a
Well,
life
whatever life
expectancy
expectancy
is,
is.
yeah,
So
yeah.
we're not quite sure what the doctors now say is a life expectancy. But out of the $10 million, my guess would be almost $9 million would be for future care. So
what breakup
would be
do you
between
think?
$8 and $9 million would
What do
be
you think the
future
breakup
care.
would be? What would she get for general damages in this, Harry?
And generals would be
Probably the maximum.
maximum.
Under the, if it was Victorian law, it'd be around 440, wouldn't it? Give
About,
or take.
yeah, under Victorian law. And then there's loss of income.
Which sounds light, doesn't it, really, for something like this? But that's the statutory cap that's been put on by the legislature to try and keep things...
Parliament's decided, for whatever reason, that pain and suffering damages are to be capped at a certain amount in Victoria. So generally it's around about $450,000 for pain and suffering.
And just curiously, how do you think they're going to assess loss of income? She was only 7.
It's an interesting question. Again, it's guesswork. You've got to look at the parents. There's some suggestion she was interested in becoming a doctor, but you know,
They said she was pretty bright.
You go to the school reports, you go to the teachers, you see what opportunities she might have had or what her goals were. But look, I'd assess it on what I would say is average weekly earnings, and you'd say that in likelihood she would have been educated and at least earned the average of what an Australian would earn till 65. And then you've got to take into account all sorts of other factors.
Vicissitudes and whatever.
What's called vicissitudes, and that's all the ups and downs of life.
Yep.
We know life doesn't go in a straight path.
You could have been this
And
that, whatever.
so the courts have just generally reduced damages to take into account the ups and downs of life. People go into the workforce, they leave the workforce, say she might have got married.
Could have
had
suffered
children.
another injury somewhere else.
She could have suffered another
Yeah,
injury.
all sorts of things.
But
Okay.
but part of a future loss is what would be called the voluntary assistance of the parents and friends and relatives. So they would be giving a care, wouldn't be from...
It's gratuitous and domestic care. That's
Domestic
how they
care.
define it under legislation these days.
And there's a very famous case that is quoted throughout Australia called Griffiths and Kirkmeyer. And we may come back to that after the break, which deals with people who are injured and then what happens to their families and how their families have to take care of themselves and how the courts look at it.
Yep.
Because it's unusual circumstances, but the courts have evolved a doctrine of trying to
Compensate people that...
compensate
the
the people.
plaintiff for the people that are looking after them.
Yeah, compensate that. But we'll discuss that case in more detail after we come back from the break. Griffiths and Kirkmeyer, it was Mr. Kirkmeyer who ran the case, and it was decided in the High Court in 1977. So it's, again, law students around Australia quote that case regularly.